So my name is Peter Ligarius. I'm the chairman of the Hellenic Law Society, and I'm pleased to let you know that we have a talk by our own member, Leo Spanos, on the consumer bankruptcy statute and laws. Leo is a partner with the law firm of Jen Lee Law in the East Bay. I believe it's in San Ramon. And he's been practicing bankruptcy law for a significant number of years. He was working for a Chapter 13 trustee for a number of years before he became a partner at Jen Lee Law. He's lectured extensively on and written on franchise on bankruptcy law, and he's also been an adjunct faculty member at JFK University College of the Law in the East Bay, which is now part of National University, where our own member Chris Canos is a professor. And with that, Leo, I turn the floor over to you to tell us about consumer bankruptcy law.
Okay, well, thank you, Peter, and thank you for allowing me to give this presentation. I'm happy to do it. I'm a proud Greek American. My father is a proud Greek American, and he was been a member for I don't know how many years. And he's always had a great experience and a lot to say about the Hellenic Law Society. I think he was an Athenian. He got the Athenian Award a couple of years ago. He's a retired Contra Costa County judge. And so I'm honored to be here to talk about what I do in the world of bankruptcy. So I'm going to start out by just giving a little bit of an overview of bankruptcy law. Bankruptcy law is in the Constitution, actually. So there's statutory authority and in federal law, but it comes from the Constitution. Article 1, Section 8 says, Clause 4, Congress shall establish uniform laws on the subject of bankruptcies. This is known as the Bankruptcy Clause. Anyone who practices bankruptcy knows what that is. So it's based on the Constitution. It comes from the Constitution. In addition, there's federal statutory law, and Congress has passed several laws regarding bankruptcy over the years. The bankruptcy laws are known as the Bankruptcy Code or the Code. It's Title 11 of the United States Code. The code is supplemented by the federal rules of bankruptcy procedure, known as the bankruptcy rules, and they incorporate the federal, most, if not all, but generally speaking, they incorporate the federal rules of civil procedure and the federal rules of evidence, with some exceptions. The bankruptcy code has 9 chapters. I'm not going to bore you and go over each chapter. That's not why I'm here, but there are 9 chapters of the bankruptcy code. Certain chapters are applicable to all bankruptcies. So those would be 1, 3, and 5. Chapter 1 is definitions, but those are applicable to all types of bankruptcy. Generally speaking, there's 3 types of bankruptcy that everyone knows about that take up are the majority of all cases. When people think about bankruptcies, there's 3 types of bankruptcies: Chapter 7, Chapter 11, and Chapter 13. I'm not going to go over, there's one for municipalities, cities that, they can file for bankruptcy, farmers and fishermen, that's they special code section for them, and international or cross-border insolvencies. I'm not going to be spending time talking about those. That's not my area of expertise. And the majority of bankruptcies are chapters 7, 11, and 13. Chapter 7 is known as liquidation, or what people call straight bankruptcy. It's what most people think about when they think about bankruptcy. It's for individuals and for businesses. The goal is for at least individuals to get a bankruptcy discharge. It's a bankruptcy discharge is a court order. It's an order signed by the bankruptcy judge, saying that the individual filed is no longer legally or liable on their debts, most of their unsecured debts. There are some exceptions, and I'll briefly go over those, but generally speaking, it's an order saying the debtor, the person who files for bankruptcy, is not liable on these debts. The goal is to give individuals the honest, it's based on a Supreme Court case, the honest but unfortunate debtor a fresh start. The goal for businesses, a business bankruptcy is a little bit different. A business Chapter 7 is an orderly process to close down, shut down businesses. Businesses do not get a discharge. They don't need a discharge because they're going out of business. But Chapter 7 liquidation, it's called liquidation, and it's a relatively quick process, at least for individuals, as compared to the reorganizational chapters, which I'll talk about in a minute or two, Chapter 13 and Chapter 11. So for individuals, usually 3 to 6 months. It could be longer if the case is what's called an asset case. It could be longer. The bankruptcy could take longer. I don't know if Mike is on, but Mike Kasolis is a Chapter 7 trustee, so he is an expert on that. He could talk to you more about that. But typically, Chapter 7 cases are a lot shorter than certainly Chapter 11 and Chapter 13 cases. And the goal is for an individual to get a discharge of their debts. Chapter 11 is business reorganization. Chapter 11, the goal is for the debtor or the business, and they are known, the debtor is known as a debtor in possession or DIP, to reorganize itself and continue to operate. So Chapter 7 would be to liquidation, go out of business. Chapter 11 is a corporate or business reorganization. It's a complex process, expensive process. Think of like Macy's or GM or, big companies that are reorganizing their debts, and they want to, PG&E is another one. Their goal is to remain in business. Maybe they had a bad lease. They need to get rid of a lease or reorganize a lease or do different things. But the goal is for them to remain an ongoing concern. So that's Chapter 11. Chapter 13, and I worked for Chapter 13 bankruptcy for trustee for 11 years in Oakland division. So all Chapter 13 cases that were filed in Alameda County and Contra Costa County went through that office where I worked. That's kind of my bread and butter before I went into private practice. Chapter 13 is similar in many respects to a Chapter 11 case, except it's for individuals. So it's for individuals, small business reorganization. Now, when I say an individual, it could be someone like a mom and pop owner, someone who has a sole proprietorship. They can file for bankruptcy on their personal debts or debts that are they personally guaranteed. So Chapter 13 is not for businesses. It's not a business bankruptcy, but individuals who have personal guarantees on corporate debts or business debts, they can discharge those in a Chapter 13. I have been seeing a lot of clients in that situation where they have an LLC, maybe they're a single member LLC or a 2-member LLC or an S corp, or and it's a small business. Maybe they don't have any employees. They might be the only shareholder or only owner. And unfortunately, with the pandemic and other things that have gone on, they're no longer really able to survive. And a Chapter 13 would, I should go take a step back. If they've decided to shut down the business, and that's going to be the best thing for them going forward, they can file a Chapter 7 or a Chapter 13. And typically I'm seeing a lot of Chapter 7 cases where they will be able to get a discharge of their personal debts, like credit cards, lines of credit, certain types of taxes, and other things. And if they personally guaranteed, say, a business lease, they can discharge the liability on the business lease. if they're going to shut down the business. And because now the landlord can go after them personally, and then it becomes a personal guarantee that can be discharged into bankruptcy. So I do see that a lot. Other types of debts would be like SBA loans, the EIDL loans, which is the emergency individual loans that the SBA gave during the pandemic. Those can be discharged if they're personally guaranteed. If they're not personally guaranteed, then they're an unsecured debt, and they can also be discharged. But going back to Chapter 13, it's for individuals looking to reorganize their debt. They propose a bankruptcy plan for 3 to 5 years, depending on their income. So if they are what is known as above median income, meaning that their income is greater than the IRS standards for a household in the county where they live in, depending on the number of people they're supporting, then they have to be in for 5 years. If they're under that income, it's 3 years. And the relevant period is the 6 months prior to filing for bankruptcy. So for Chapter 7 and Chapter 13, the relevant periods with respect to looking at income and whether or not a person qualifies to be in Chapter 7 based on their income is the 6 months prior to filing the case. In a Chapter 13, it would the income for the 6 months prior would determine their disposable income available to pay to creditors. So that 6 month period is very important. It's not like, well, what did my tax returns say for 2022? It's what is the income in the last 6 months. So if someone files on July 1st, the relevant period is going to be January through June. Someone files on October 1st, the relevant period would be April 1st to September 30th. So it's the last 6 months prior to filing. So Chapter 13 is a little bit different. Like I said, it's a repayment plan, whereas Chapter 7 is just you file for bankruptcy, you have what's called a meeting of creditors. If it's not a complicated case with a lot of assets or assets that can be liquidated, it's generally a quick process unless a creditor is possibly pursuing an objection to discharge. In that case, it can obviously take a lot longer, but generally speaking, it's a lot faster than a Chapter 13. A Chapter 13, like I said, minimum is 3 years, 36 months, and up to 60 months. At the end of 60 months, or it's 36 months, depending on the person's income, they get a discharge, just like in a Chapter 7. And the Chapter 13 discharge is encompasses more debts. For some people, it might make sense, even if they qualify for a Chapter 7 based on their income, to file a Chapter 13 because of the debts that can be discharged. So that's kind of, and I'll go into a little bit more detail, but that's kind of an overview of the 3 types of chapters. Chapters 7 and 13 are known as consumer chapters. They're for individuals, with the caveat that Chapter 7 corporations can file Chapter 7 bankruptcy to liquidate. But Chapter 11 is business reorganization, and that's business bankruptcy. So key points, and I just briefly went over those. Consumer cases, when someone says a consumer case, they're generally going to be speaking about individuals, so not corporations or business, and they're talking about a Chapter 7 or a Chapter 13. Business cases, usually they're talking about a Chapter 11 is usually a business for businesses. Individuals can file Chapter 11 as well. If they don't qualify, let's say for Chapter 13, they can file a Chapter 11, but generally speaking, most people, when they think about Chapter 11, they're talking about businesses. So liquidation versus reorganization. So Chapter 7 is a liquidation chapter, meaning that someone is they're putting it all on the line. They're putting all their assets on the table, and they just need to get rid of their debts, or a business is going out of business. And chapters 11 and 13 are known as reorganizational chapters, where the debtor proposes a bankruptcy plan, 3 to 5 years. Chapter 11 can go longer. Chapter 11s are more complex. They're a lot more expensive. And they're not my specialty. My specialties would be the chapter 7 and 13s. Chapter 7 is the most common form of bankruptcy. Each chapter has its own rules for eligibility. Occasionally, someone can be forced into an involuntary bankruptcy by creditors. In my experience, this is rare. Several factors must be met, and I'm not really going to go into that. That's not something I've dealt with, but potentially an individual can be forced into an involuntary bankruptcy. The most recent form of the bankruptcy code the bankruptcy code was amended in 2005. And that's known as the Bankruptcy Abuse Prevention and Consumer Protection Act. It's a mouthful. We call it BAP-CIPA, but it's the 2005 amendments, the most recent version of the bankruptcy code. So bankruptcy jurisdiction, Congress conferred jurisdiction over bankruptcy to federal courts under section 28 USC 1334. And then there's a code, section 28 USC 157A provides for referral of bankruptcy matters from district courts to bankruptcy courts. And bankruptcy courts are known as units of the district courts. So generally speaking, the goals of bankruptcy, protection of debtor and creditor interests, efficient and fair treatment of claims, preservation of the estate, meaning that when someone files for bankruptcy, there are certain laws and rules that come into effect to preserve the assets of the person who filed for bankruptcy. Once they file for bankruptcy, all that the debtor's assets, the debtor is the person who files for bankruptcy, become property of the bankruptcy estate. Estate property can be abandoned, it can be exempt, but upon the filing in that case, all that person's property becomes property of the bankruptcy estate. And in particular, if it's a Chapter 7 case, the Chapter 7 trustees has duties, and their primary duty is to look for assets that can be sold to pay off creditors. Now, of course, individuals are entitled to exemptions. So most individuals, as opposed to businesses, their biggest asset is their house, or real estate. Under California law, and which was amended, there was a new law couple of years ago, I think it was beginning 2021 or 22, they increased the homestead exemption. What previously, I believe the maximum was up to $175,000, depending on someone's circumstances, their age, their income, different things. But now it's up to $678,000. So that sounds like a lot, and it is a huge increase. But given real estate in California, if you have a house that's worth a couple million, it's not as much as you might think. But for a lot of people for other people who maybe, they're not living in rural areas or different areas that don't have housing prices like the Bay Area, it's enough to cover all their equity. But that's if someone has, hundreds of thousands of dollars in debt, credit card debts, loans, taxes, other things, and, they guarantee leases, and they come to me and say, well, I thought I could get a discharge of all this. That's why I'm talking to you. I'm going to ask, well, do you have any assets? Oh yeah, I have a house. Okay. Where are you living? Oh, I'm living in Berkeley. Okay. Well, about how much do you think the house is worth? I don't know, 2.5. Okay. And how much do you owe on it? Oh, I owe, 500,000. Okay, well, bankruptcy, we can talk about the options, but keep in mind there's a lot of equity in your house, and you can only protect about $678,000 of that. So we want to make sure if we put you in a Chapter 7, for example, there's a good chance that, the Chapter 7 trustee is going to try to sell your house, and they'll cut you a check for $678,000. And then they're going to use the rest to pay off your bills. And if there's anything left over, of course, you'll get that. But so keep that in mind. Bankruptcy can help a lot of people, and it does. But if people have significant assets with equity in excess, in their homestead of, over $678,000, they're not going to get away scot-free. They're going to have to pay something. And if they have other real estate, well, if it's not their homestead, they can't exempt much. They can exempt maybe a very small amount, but that's definitely going to be at play in a bankruptcy. So these are the types of conversations I have. Yes, you have a lot of debts. Yes, the debts can potentially be discharged in a bankruptcy, but there's something called the liquidation analysis, which is crucial to all types of bankruptcy, 7, 11, 13. And the liquidation analysis is based on what a creditors would get in a hypothetical Chapter 7 liquidation. So I gave the example of the house. There could be other types of assets. Like I said, someone could have other real estate, rental properties, secondary houses, things like that. You're not going to be able to exempt much, if anything, of those. The other types of assets, would be, interests in stocks, bonds, equities, interests in businesses, if they own a business, if they're partners in businesses, if they have a percentage ownership in businesses, those would all be part of their potential bankruptcy estate in a Chapter 7. And they could all potentially be liquidated or sold. You'd have to put a valuation on that in your bankruptcy, and they could be sold to pay off your debt. So those are all things to consider with bankruptcy. So let's talk about the actors. Bankruptcy courts. The bankruptcy courts, we all know what that is, what they are. Bankruptcy judges. California, there are bankruptcy districts in the Northern District, Eastern District, Central District, and Southern District. And within those districts, there are different divisions. So in the Northern District of California, there's the San Francisco, Oakland, San Jose, and Santa Rosa. There's also the Eastern District, Sacramento, and some other divisions. And then Central is LA, and Southern is San Diego, and they have different divisions within those. The United States Trustee Program. So if you talk to someone who is in bankruptcy, files bankruptcy, an attorney, they're going to talk about the UST or USTP or the United States Trustee. That refers to the United States Trustee Program. It's a division of the Department of Justice. Each judicial district is assigned one or more United States trustees who oversee the administration of the bankruptcy case and private trustees. So the United States Trustee Program, we're talking about executive branch, right? It's coming down, President, Department of Justice, you've got, and then underneath them, one of the divisions of the Department of Justice is the United States Trustee Program, and they're the ones that oversee bankruptcy cases. So they have certain duties contained in, listed in federal statute. I'm not going to bore you with those, but they are a national program. This is from their website, a national program with broad administrative, regulatory, and litigation enforcement authorities, whose mission is to promote. This is what they do, what they say they do, and this is on their website: the integrity and efficiency of the bankruptcy system for all stakeholders, debtors, creditors, and the public. So the Eastern and Northern districts of California and Nevada are in Region 17. The United States trustees appoint and supervise private trustees who administer consumer cases under Chapter 7, 12, and 13 of the Bankruptcy Code. Private trustees, now when I say private trustees, those are Chapter 7 panel trustees and Chapter 13 standing trustees. They are appointed by the United States Trustee Department, but they are technically private and independent. They run their businesses, their offices independently with oversight and regulation by the United States Trustee Department. So Chapter 7 trustees are known as panel trustees because they're appointed to a panel in each district, and they're assigned cases based on a blind rotation. So you don't know who you're going to get. If you file a Chapter 7 case for a client, can't predict. I can't predict it's going to be, Mike Casolis I'm going to get. As much as I would like to get Mike in every case, I can't predict who I'm going to get. So there's a lot, it's a blind rotation. And like I said, when someone files for bankruptcy, if it's a Chapter 7 case, all their assets become property of the bankruptcy estate. So if Mike Casolis is the trustee, the trustee, which would be Mike, has control, all your assets become his assets, at least with respect to the bankruptcy. They're property of the bankruptcy estate, but you can trust him. So their duties are set forth in Code Section 704 of the Bankruptcy Code. Chapter 13 trustees are known as standing trustees. So there are a lot less of them, and their jurisdictions are wider. And they administer cases, within certain geographical areas. So, for example, my trustee, it was Alameda County and Contra Costa County. And they evaluate the financial affairs of the debtor, make recommendations to the court regarding confirmation of a bankruptcy plan. They can file objections to claims, and they administer the court-approved plan by collecting payments and distributing them to creditors. There can be Chapter 11 trustees, but they're not appointed in every case. It's under certain circumstances. If there's cause shown where it's necessary to protect the rights of creditors or other interest holders. So generally speaking, in a Chapter 11 case, if it's a business, there's no Chapter 11 trustee. The business takes the place of the trustee, and they're known as a debtor in possession. So if you hear the name debtor in possession or DIP, it's a Chapter 11 bankruptcy with a business debtor. Why do people file for bankruptcy? Well, their primary goal is to get a discharge. So like I was saying before, a discharge is a bankruptcy court order saying that you're no longer liable on certain debts. Most unsecured debts can be discharged in a personal Chapter 7 or Chapter 13 case. So these include credit cards, personal loans, lines of credit, some types of taxes. Generally, if the taxes are 3 years or older and the individuals filed their returns on time, they can get a discharge of their taxes. If they're within the last 3 years, they can't get rid of them through a bankruptcy. So the other types of debts, medical bills, collections, and personal liability on secured claims. So mortgages, cars, things like that. They can get a discharge of the personal liability, but the creditor is going to retain the liens the way that the Supreme Court said they ride through the bankruptcy. So you can't get rid of liens through a bankruptcy, but you can get rid of a personal liability. So that means that if someone has a house, they want to keep their house. Well, if they want to keep their house, they better make their payments. If not, the creditors can still foreclose. They'd file a motion for relief from stay and say that the debtor's not making their payments, and then they can foreclose. So cars, mortgages, things like that. If the person wants to keep the property, they need to continue making payments. Business debts that are personally guaranteed can be discharged. So if, like I was saying before, if the person has a business, maybe they're a single member LLC or C Corp, S Corp, or if the business shuts down, if they shut down the business and dissolve it, then these debts, if they're personally guaranteed, then creditors can go after them personally. They can say, look, This was a business debt, but the LLC shut down and now I'm going after you personally. Well, those can be discharged in a bankruptcy. So personal guarantees on business loans, business debts, I'm seeing a lot with the SBA, business credit cards or lines of credit if they're personally guaranteed. So those are all potentially dischargeable in a bankruptcy. Secured claims and liens are not affected by a bankruptcy discharge. So this is what I was saying before. Someone can get rid of the right to pay, meaning that a creditor, the bank can't sue them personally for money damages, but they can still foreclose. So bottom line, if someone wants to keep their property and they have a secured claim, a mortgage or a car loan, they got to continue making that payment. They can make the payments either through the bankruptcy plan, through their bankruptcy plan, if it's a Chapter 13 case, or directly, if it's meaning that they can just continue to make their installment. If they're current on them, they can continue paying the bank for their mortgage or paying Toyota for their car. That's not to say there's some caveats to that. There is something called what's called a lien strip. And a lien strip can be in a chapter. You can't do this in a Chapter 7, but you can do it in a Chapter 13 and a Chapter 11. If someone has several mortgages on their property, if they have junior mortgages, and there's no equity in them. So essentially, if a person is underwater on their house, on their first mortgage, so they owe more than the first mortgage. If they have junior liens, they can strip them. So this is potentially a very powerful tool in a Chapter 13 or Chapter 11 case. So if someone has a $200,000 second and a $300,000 third, and they just were way overextended, but they're upside down on their house, they can file a motion to value the lien, and if the bankruptcy court determines that there's no equity in them, they can get rid of them in a bankruptcy. Now, in a Chapter 13, at least, not a Chapter 7. But what that means is the debt is then treated as a general unsecured creditor, so it's lumped with your credit cards and other types of unsecured loans. So that's potentially a very big tool and can give a very big benefit for Chapter 13 and 11 clients. Certain unsecured claims are known as priority claims, and they are not subject to discharge. So these claims, you can't get rid of them. Like I was saying before, recent tax liability, if it's within the last 3 years, or if someone hasn't filed a return and there's an assessed amount that they owe, those you can't get rid, they won't get discharged in a bankruptcy. Domestic support obligations is another big exception. Can't get rid of those in a bankruptcy. Administrative claims, these would be for like attorney fees in a bankruptcy, not like the attorney who files the case in a Chapter 13. They can have their fees paid in the Chapter 13 bankruptcy plan. In the Chapter 7 and 11 context, there could be administrative claims. So if a Chapter 7 trustee needs to hire an attorney to do some work, or hire a broker, or hire anyone else, a professional, they can do that, and those will get paid. Those get paid out from the bankruptcy. They're called administrative claims. And the debtor can't say, I didn't want to pay for the Chapter 7 trustees attorney fees. Well, too bad. That's the way it goes. Other types of claims, wages, salaries, employee benefits, those you can't get rid of them in a bankruptcy. Other types of non-dischargeable debts. So Section 523 of the Bankruptcy Code has a list of debts that are just not dischargeable. Some of them I talked about before: priority taxes. Those were the recent income tax liability. This isn't a list of all of them, but some of the main ones. Obligations incurred by fraud. So, if someone commits fraud, they can't get rid of that in a bankruptcy. Debts arising from dishonesty as a fiduciary, embezzlement, larceny. domestic support obligations I mentioned before, those are non-dischargeable. You can't get rid of them. Now, the way some of these are just on, like if it's a domestic support obligation or student loan, which is another one, nothing needs to happen. The creditor doesn't need to file an action in the bankruptcy court to say, hey, my debt's not dischargeable. Some of them are just not discharged. Nothing needs to be done. But if you're trying to show fraud or dishonesty, embezzlement, larceny, willful or malicious injury, or, you damage someone or harm someone because you were driving under the influence, that's another one. Those you need to file what's called an adversary complaint in the bankruptcy. So it's a complaint inside someone's bankruptcy where the creditor is going to say, look, this person did a really bad thing here, and they committed willful and malicious injury against my client, and this debt should not go away. So that's something to keep in mind. Even if someone files for bankruptcy, a creditor can file an action or it's called an adversary proceeding in that person's bankruptcy to say, my debt shouldn't go away because the debtor did something really bad here and I can prove it. So that's something else to keep in mind, especially when you're talking to clients about potential bankruptcies and maybe other attorneys, and they're like, well, my client says this, my client said that, and I don't know anything about bankruptcy. What do I do? Well, I mean, things to keep in mind. If it's something you think there's an argument that's based on fraud or willful or malicious injury or something to that effect, there are certain types of debts that you can't get a discharge of. So that's non-dischargeable claims. What's the number 2 reason in my experience that people file for bankruptcy besides the discharge? It's something called the automatic stay. So the automatic stay is an injunction arising by operation of law that comes into effect automatically when someone files for bankruptcy. So you don't need a separate court order. You just need to file the bankruptcy. You list the creditors in your bankruptcy, and the automatic stay comes into effect. It stops all legal proceedings outside of the bankruptcy forum against the debtor, against their property and estate property. So the distinction there, when I say against the debtor, I'm talking about personal damage, in personam money damages. So that stops all proceedings against someone from suing the debtor for money damages. When I say property in rem, meaning it could stop a foreclosure or it could stop a repo. So it stops a creditor from taking actions with respect to the property. So that is a very powerful tool. So if someone's being harassed, someone has a notice of foreclosure, someone just got served for a lawsuit, with certain exceptions, that all stops. If the creditor wants to pursue the debtor personally or with respect to property, like foreclosure or something like that, they need to file a motion in the bankruptcy court. It would be a motion for relief from stay. Happens quite often, but it's a powerful protection. Key points, like I was saying before, there's no court order. You don't need to apply for this. Once you file a bankruptcy, it automatically goes into effect. Stops all legal proceedings, enforcement and collection efforts, enforcement and collection. So if the trial is going on, it puts a stop to it. If the person's already found there's already a judgment, it puts a stop to enforcements, garnishments, IRS garnishment, any garnishment that goes away unless they go into court and file a motion for relief from stay with the court, with the judge. Applies to all types of debtors. So it applies to individuals, human beings. When I say individuals, I mean humans, businesses, corporations, partnerships. It applies to any person or entity that files for bankruptcy. Stays into effect until the case is closed, dismissed, or lifted upon request from a creditor. So lifted means that the creditor goes in and files a motion. So they're going to have to find a bankruptcy attorney, hire the attorney. So it's an additional expense. I mean, if there's enough money involved, that's not going to be an issue. But if it's a small amount, they're probably going to say, screw it. I mean, they might say, I can't afford a bankruptcy attorney. I don't want to hire a bankruptcy attorney. They're going to have to do work. It's going to be expensive. I'm not going to get anything out of it. But if there's enough money involved, they'll do it. But they need to file a motion and show that they are entitled to proceed with their enforcement or collection activities. Once the discharge, or like I was saying before, once a debtor obtains a discharge, the automatic stay is succeeded by something called the discharge injunction, meaning after you get a discharge, if a creditor then goes after you and says, hey, you still owe me, Chase, like starts suing you or sending you things, picking Chase, it could be any creditor, on a debt that's been discharged, that would be a violation of the discharge injunction. And so you could go back into the bankruptcy court and seek damages and sanctions against the creditor. So that's another powerful tool. Once you get the discharge, if a creditor continues to harass or go after someone, they can go back into the bankruptcy court and seek sanctions based on a violation of the discharge injunction. Most courts treat violations of the automatic stay as void, meaning if a creditor takes action after bankruptcy case was filed, most courts are going to say that action is just void. The debtor doesn't need to do anything to make it void. It's just automatically has no legal significance. The stay is not an end in itself. So the automatic stay does not determine the validity or amount of claims. It simply suspends actions on claims outside of bankruptcy. Now, there are some exceptions. So the stay does not cover everything, and I'm not going to go over every exception, but just keep in mind there are some exceptions. So if a case comes up and you're not sure, either talk to a bankruptcy attorney and they can tell you. For example, in the family law proceeding, and there's a lot of crossover between bankruptcy and family law matters. And so I have one right now where the issue came up. Someone was trying to modify a child support. Now, they can modify child support. Modification of child support orders is not covered by the automatic stay. So they can do that. But if they're trying to modify spousal support, that they do need a court order. They would need to go into the bankruptcy court. If they're trying to, let's say, set aside a marital settlement agreement, they need to go into the bankruptcy court and file a motion for relief from stay and get an order allowing them to do that. Other exceptions include if it's a criminal action, commencement or continuation of a criminal action that is not covered by the automatic stay. That's a criminal matter. It's not a civil matter. It doesn't have to do with money or damages or anything like that. Continuation or commencement of an action to establish paternity is not covered, or to establish or modify a domestic support obligation, concerning child custody or visitation. So those actions are not covered by the automatic stay. Bottom line, if you're not sure, look it up, do a Google search. If you can find the answer and you feel confident about it, great. If you can't, or you're not clear about it or have questions, talk to a bankruptcy attorney and they can tell you what's in and what's out. Does anyone have any questions?
I have a question, Leo.
Sure.
When the amendments were passed in 2005, there was sort of a general myth that credit card companies would be able to stop discharges. Can you elaborate on what that myth is wrong, or what was it based on?
Yes, I think there is. So I would say the 2005 amendments were creditor friendly. I'll just put it that way. And so the main focus of the 2005 amendments was something called the means test, meaning that prior to that, bankruptcy courts had some had latitude in terms of bad faith and evaluating a individual's income and their assets and their expenses, and saying, wait a second, you can't pay $500 for pet expenses at the expense of your credit cards. Or depending on the judge, maybe the judge had loved dogs and had a bunch of dogs, and the dogs had high expenses, and maybe the dogs were sick and he was paying for their treatment, and they'd say, okay, well, that looks good to me. Sure, you can do that. For example. But so there was discretion for judges to evaluate based on the community they were presiding in, the area, what was reasonable or not. So the 2005 code introduced something called the means test. What it was meant to do was take discretion outside, to remove the discretion of bankruptcy court judges to determine whether or not someone qualifies for Chapter 7 or should be in a Chapter 13, or how much money they should be paying to their creditors. The idea is you look at the last 6 months of a person's income, and based on that, you're going to determine whether or not they qualify for Chapter 7. So if someone is making more than that median income, they're probably not going to qualify. There is something called a means test. So you look at the income, and if the income is above what the IRS standard is under the means test, then you can fill out a form, and they're going to look at and this is from the IRS guidelines, they're going to look at your rent, your mortgage, utilities, what food expenses should be. And at the end of that, there's going to be a number. And depending on that number, it's a mechanical test. Generally speaking, it's a mechanical test. They're going to say you're in, or this is an abuse of, it's considered an abuse. And if it's considered an abuse, they're going to say you can't file for Chapter 7. You have to file for Chapter 13. You have to be in for 5 years, and you're probably going to have to pay something to your credit cards. So that was the big thing that credit card companies did. They said, look, this should be based on a means test. It should be based on someone's income, and they determined the income would be the last 6 months. So they removed a lot of the discretion. So some people, so not everyone can just file for Chapter 7 and get rid of their credit card debts. Now, the other thing is there is an 8-year, the myth about, you file for bankruptcy, if you file for bankruptcy, how long will it be before you can file for another bankruptcy? So for Chapter 7, it's 8 years. So if you get a bankruptcy discharge in a Chapter 7 case, you have to wait another 8 years before you can get another discharge. That doesn't mean you can't file another bankruptcy, but you just won't get a discharge, which for most people, that's the main reason why they file for bankruptcy. So there's that 8-year rule. You have to wait at least 8 years before you can get another bankruptcy discharge. And I believe that was added in the 2005 code as well. But the main thing is they tied it to an individual's income, and they took discretion out from the bankruptcy judges to determine whether or not someone should be in a Chapter 7 and just really be able to get rid of their credit cards, for example, and move on with their lives.
So I have a follow-up question, Leo,
Sure.
and then I'll let other people ask theirs. So if somebody has a high income and they're above the mean, they can't file Chapter 7, so they have to file Chapter 13, and they're going to have to pay their creditors something for anywhere from 3 to 5 years, depending on where they fall.
Yeah.
And how much of their debt do they have to pay? Are they going to have to pay all of it in the 5 years, or a percentage of it? How's that stack up?
Yeah, good question. And there's two main things to consider in that. One is the liquidation or the equity evaluation that I was talking about. So if someone has $1 million of equity, I'm just going to give a ridiculous, $1 million of equity in their real estate. So they can only exempt up to $678,000 if it's their home. Let's just say it's their home. So that means, all other things aside, there's $322,000 that either they'd need to pony up in a Chapter 7. If they file for Chapter 7, they'd have to come up with that money, or the Chapter 7 trustee would sell their house. If they don't have that money, they can file a Chapter 13, but they'd still have to pay that $322,000 to creditors, but they'd have 5 years to pay it. So the first test is the liquidation or the equity test. What's the equity in their property? What can they exempt? Well, the more precise question is, what is the non-exempt equity in their property? So they could have equity, but if they can, like cars, you can exempt $7,500. Like I was saying, your homestead, you can exempt up to $678,000. You know, there are other, like bank accounts, you know, checking, savings. There's actually, it's up to the amount that's reasonable and necessary for their support. So that could be that. Often there could be litigation about that, or there could be, if you could have a Chapter 7 trustee who's going to say, look, they have $50,000 in their bank account, they can't exempt that all. And then my response would be, yeah, but she's a widow and she just lost her husband, and the husband was the primary care, he was the primary income earner, and hasn't been working, and she's going to need that money to care for herself and for her, 3 kids. So you get exemption. So the question is, what is the non-exempt equity? The non-exempt equity is going to determine how much of the debt they need to pay. That's the first test. How much of the debt they need to pay. So if it's 100,000, then they'd have to pay at least 100,000. Now there's a separate test, and the separate test is the disposable monthly income test, which is related to, well, it is the means test. So like, the means test is kind of a gatekeeper into Chapter 7. If you pass it, you can stay in Chapter 7. If you don't, then you need to go to Chapter 13, and you would file another means test. And it's similar form, similar question, similar calculation. And based on that form, they're going to say, look, you made in the last 6 months, you made $300,000, and your yearly, income is, your gross is about 600,000 a year. Well, you're going to have to pay a lot of money to your credit cards, and based on that, you're going to have to pay a lot of money to your unsecured taxes based on that. So the second test is the income test and the means test. So you plug in their income, and there's a form that you fill out, and the form has allowances or deductions that you get to take based on the IRS guidelines and standards. And at the end of that, there's a number called disposable monthly income. So, if it's $500, let's say what that number is, that's the amount that you need to pay to your unsecured creditors, your credit cards, unsecured, lines of credit, things like that, medical bills, things of that nature, older taxes. It would be $500 per month, or 500 times 60, which would be 30 grand. If my math is right, over 5 years. So there are 2 tests. One is the liquidation test. What's the amount of equity that you can't protect? And the other one is this income test. So those are the 2 factors. So if someone's making a lot of money, they're probably going to have to pay, they're going to pay a portion, potentially all their debts over 5 years. Now, in some cases, that might make sense to them if they're paying 30% interest on credit cards, and they have the ability to pay it out over 5 years, then probably makes sense. Or maybe they have taxes, and they can't get an offer in compromise or an installment plan. For whatever reason, it's not going to make sense. The bankruptcy will cut the interest and penalties generally. So it stops as of the date they file, the interest and penalties stop, and then they just pay it off over 5 years. That was a long-winded answer, but
No, it was a good answer. I'm going to ask Michael, our trustee friend, if he has any questions.
No, Peter, it's Mike here. Hang on one second. Let me turn on. Stella and I have our we have our both on our phones, so we're getting a little echo there. I don't have any questions. I was just saying to Stella that Leo's doing a great job. It's a great basic overview, gives an idea of where things are at, and kind of where you fall in these categories. For most part, most people are consumers and they fall in the Chapter 7 arena. You do have some individual Chapter 11s too, and there's some requirements that you kind of fit into those. I administer those cases along with the business Chapter 11s too. And if anybody has any questions in the society, that Leo can't answer, or you need specifically about how a trustee would approach things, always feel free to reach out to me and send me an email or call me. And great
And
job, Leo.
Zach,
Thank you.
thank you,
Yeah.
Michael. And Zach, you represent a lot of restaurants. You probably bump into this field.
Yeah, I was interested in particularly in Leo and what you had to say about guarantees, because a lot of my clients, when
Right.
things don't go well, they're, a big consideration is that they have guaranteed the leases, they've guaranteed, or the individuals as,
Right.
they've guaranteed other obligations as well. And it's interesting to hear that can be discharged, but I guess through a personal bankruptcy.
Right. Yeah. So I get a lot of cases, and there's a lot of confusion. Some people who own businesses, they're going to be like, "Oh, I need to do a corporate bankruptcy. Someone told me I should do a corporate bankruptcy." And I'm like, "No." But when they tell me what their issues are, I'm like, "No, you don't want to." First of all, you're in the red. You've been in the red for the last year. You're not making money. You're barely making payroll and quarterly taxes and things like that. If you wanted to do a business bankruptcy, it'd probably be $25,000 to $50,000 retainer. It'd be a long, complex process, and it would only be for your business. So it's not going to help you with any other debts.
Right.
It would be a business. It'd be a business, and when I tell them that, they're like, "That's not what I want to do. I have this personal guarantee, and I need to get out of it." I'm like, "Okay, well." Then you need to file a Chapter 7 or maybe a Chapter 13. And the big consideration for them is, do you want to continue in the business? How is it an ongoing concern? Are you making money, or would you rather just maybe shut down, start something new? I mean, you don't want to get into transferring assets from one entity, fraud and things like that, obviously. But maybe you shut down. Maybe look for other work, or you can start a new business after, and then you can discharge the personal guarantees. So and then when I say that, a lot of them like, "Oh, okay."
No, we get a lot of well, not a lot, but I mean, some of our clients have, especially after COVID, have I mean, in some sense, if they're lucky, they have enough assets in the business where they can sell it as a going concern,
Right.
get enough money to perhaps pay off their debts and walk away from it all. But more often, they wind up with some sort of personal liability. So this is good to know. I never really thought about personal bankruptcy to advise them to look into that.
Yeah. And when you have bankruptcy, they're called business cases. Those are a little bit more complex, and you got to ask, what are the assets? I mean, the bankruptcy trustees, and Mike can attest to this, they're going to want to see the financials, the balance sheets, the P&Ls, the bank statements, list of assets. They're going to want to do their due diligence to determine whether or not there's really, if there is anything, right? Liquor license is one that's come up a couple of times in my experience, where someone has a liquor license, they don't really think about it, and those can have value.
Oh, in San Francisco in particular, that's usually, for my clients, that's the ace in the hole, like as far as like having something they can sell that gets them out of everything. In other counties, not quite as much, but in San Francisco, they certainly have a lot of value.
Yeah.
Do you find, Leo, that landlords with personal guarantees will take a small settlement rather than having the client the guarantor to have to go into bankruptcy Is
A
that,
lot of time, yeah. So that's a discussion I have with my clients a lot. Whether or not we want to maybe just if that's the big thing, like a personal guarantee on or a landlord or a lease, maybe we try to negotiate. So that's something else I do. It's not everyone wants to file for bankruptcy, and it's not in everyone's necessarily their best interest, depending on their overall financial situation. So a lot of times we'll reach out and we'll try to negotiate with landlords. It's really hit and miss. I think the bigger corporate landlords, those are ones that it's tough. It's tough. It takes a while and it's more difficult. I'll say that because they have to go back to maybe shareholders and find out, well, what can we do here? Are we just going to ignore it? How much can we get? And whereas if it's like a smaller business or landlord, or certainly if it's an individual landlord or a small company, maybe you get better success. So but the landlords are struggling, and I think in San Francisco certainly, and everyone here can attest to that. Commercial real estate is the values are not good. And so they don't want to negotiate, and they might be in a position where they can't. That didn't was it Westfield in the mall? Did they file for bankruptcy, or did Nordstrom left? I think that they left the lease. So they're struggling as well. So it really depends, but that's something, a service that, sometimes it'll just be, instead of filing for bankruptcy, we'll start off with a retainer to try to negotiate, to see if maybe we can come to a resolution, if that's the thing keeping them up at night. Yeah.
so we have Hillary, Costa, and Stella haven't asked a question. I know you've got a burning question over there, Hillary or Costa or Stella.
No question for me. I can just ask my husband.
Yeah, no, I have no questions. Thanks.
Yeah. And I should say the big kind of news in bankruptcy is student loans are back. Repayments are back. Student loans, like I was saying, they're not automatically dischargeable. You have to file a complaint. It's to get rid of them. That was another concession, I guess, in the 2005 amendments. Bankruptcy student loans are not dischargeable unless you can show it's an undue hardship, which requires filing an adversary complaint, which is someone who can't even pay their student loans. They probably don't have the money to pay for a complaint in their bankruptcy. But the Biden administration, they have new guidelines streamlining the process. So depending on I will just generally speaking, I would say if someone is maybe they're on disability or they have been Social Security, they're older, retired, a fixed income, or maybe someone who's just really struggling and they're not making much money at all. Like it's hard I don't have the exact dollar amounts, but there is a new process, guidelines that's going to streamline them so that the Department of Education can really say, okay, well, these people, they actually do deserve a discharge of their bankruptcy, a discharge of their student loans. So that's something that I think you're going to see a lot more of, since student loan payments are beginning again next month. So fixed income, Social Security, disability, things like that. Think in the back of your mind, if they have student loans, they might be able to get them discharged now.
Leo, are you hearing about all these cities in California that have finally gotten rid of their COVID landlord bars on landlord lawsuits against tenants?
Yeah, right.
It's like it's going to be a floodgate of these cases.
Yeah, I have heard that. And I think a lot of people are scared. And I can't remember if it's Alameda County or maybe San Francisco. There, it's not like, from my understanding, it's not like black and white. I think depending on when they missed their payment, for if it was during certain time periods, they can never be, I don't think they can evict them, or they can sue them for damages. But a lot, if not all, but if it's after that, if it's after whatever that deadline, whatever those dates are, then they can be, I believe that, yeah, they can be evicted. And residential and commercial evictions, I think, are on the rise. So, for a while, they, if they could show that they didn't barely even need to show if it was COVID related, and I don't know how deep, the government agencies looked into to determine whether or not it was COVID related. But I think they probably needed to file a declaration or provide some evidence. But yeah, those are gone. And so, so someone who's facing, eviction, if over rent, things like that, they can potentially, bankruptcy would be an option if they can cure, if they want to redeem, not redeem, renew.
They want to get rid of the debt, but they
Yeah.
can't stay
Yeah.
in the premises beyond, once the stay period by the
Right.
city
Yeah.
has ended.
Yeah.
If they're not paying their rent, they can get evicted, and
Yeah.
bankruptcy won't
Yep.
stop them.
Yeah. So, yeah. And like I said, it's kind of like with the mortgage. It's like, if you want to stay there, it's the same thing with the lease. Yeah, you have these arrears. You can provide for them in your bankruptcy plan to pay them back. But if you want to stay in the house, and you gotta pay the lease going forward, right? You got to pay, like mortgage arrears. If you fell behind, yes, you can get the protection of the automatic stay, so they can't foreclose. But you're going to have to, in a 13, you have to provide for your arrears. So you have to pay off your arrears. You get 5 years to do it. But if your installment payments are $5,000 a month, you still got to pay the $5,000 a month. So that's something to, people don't like, unfortunately, sometimes they just people can't afford it. And, but you try to give them the options, so that maybe someone can help out, and they can get into bankruptcy and pay off their arrears, and continue to live in the property. Maybe they rent out a room, they do different things, get creative. But bankruptcy gives them that opportunity. Yeah.
Leo, on behalf of the Hellenic Law Society, of which you're a proud member, I want to thank you for your talk. And it's 6:15. I will send out MCLE credit forms and the materials that Leo provided to me to all of you. I've taken your names down. It may not come out till early next week, but I want to thank you on behalf of the society and wish everyone a great evening.
All right. Thank you, Peter. I appreciate it. And it's been a pleasure talking to everyone, and we'll see each other around.
Great job, Leo. Thank you.
Thanks, Mike. Thanks, everyone.
Hellenic.
Hellenic.
Yeah.